It's time to take a look at our legal corner here on the show. We do this every Wednesday afternoon. Chris Dimakos, CJAD 800 legal contributor, is on the line. And Chris, interesting story here. You know, we've talked in the past from various sort of points of view of what to do as an employee when you're terminated in terms of severance and NDAs and all that kind of stuff. But you're going to mention here something about a recent decision by a federal tribunal against a media company, in this case Shaw Media, that really deals with something that's been sadly very prevalent in the industry of late, and that's a lot of people basically being terminated, right? Jobs have been taken away. And how does this address it, and what does it address?
It's a real important case, and for the following reasons. First of all, the employee in question here was fired for performance, not because of industry layoffs and how the industry in general is not doing well, and that's why companies are trying to cut down on the jobs. But in this case, it was a performance issue, and they terminated the employee based on a lack of performance, which the courts at every level where they challenged this, they found that there was not enough there to be able to terminate this employee. Like it was made wrongfully. There was an unjust dismissal. So we got that across. But it's when it comes to what you can claim as damages is the reason why this case is so groundbreaking. Usually, in these cases, you have severance, right? So you get terminated without cause. You take a look at how many weeks per year of service that unjust dismissal requires to be able to make things right, and they do a calculation based on your years of service and your age and how hard it is to find another job, and they put a number on the number of weeks per year of service. Or what you had as an option was if you can get reintegrated. Sometimes the court can say you can get your job back, and we're going to pay you your lost wages from the time when you were fired up until the date of the judgment when you're ordered to get your job back. So it was usually either or. But this case here says, no, it doesn't have to be either or. It can be both. It can be lost wages. It can be severance. We're going to take a different approach, which is an economic loss approach, which means basically saying that, you know what, we're not going to be bound by very rigid rules here. We can take a look at what this wrongful termination cost this employee, and we can compensate them accordingly without limiting ourselves to this formula or that formula. And that's groundbreaking. And the reason is employers now are not so happy with this because it can end up costing them a tremendous amount of money for making a mistake by letting someone go without just cause. So the point of this story is the scope of what you can claim and how much you can claim because of a wrongful dismissal just went up a lot. And we'll see it's a federal ruling, right? So it applies to federal employees. But we're going to see now if this thing trickles down into the provincial legislated that we have, the judgments and the legislation that we have. Mm-hmm. We'll see if there's a ripple effect. But it's definitely a very important decision with regards to damages for a wrongful dismissal.
So let me ask the question, because when you say wrongful dismissal, I'm trying to think now from the employer's point of view, when they can simply say, look, you're supposed to be doing this, you didn't do that, and therefore we're going to let you go. You're making it seem like this case would look at that and go, yeah, that shouldn't be allowed even as wrongful dismissal, which kind of makes me want to ask the question, how can you terminate? At what point can you terminate somebody based on the job they were supposed to do versus the job you've judged them to have done?
Right. So it's a great question. And employers ask me that all the time. Like, can we even fire somebody? Are we allowed to fire somebody? And the answer is, it depends on the facts. So, for example, if it's performance, if you have an employee who's been with you for 15 years, and they've had 15 years of stellar performance reviews and great reviews, and they've met objectives, and then there's a change in a manager, and then there's 2 negative reviews that say that they're not meeting expectations, and then they get fired. The courts will be like, well, 1 second here. We have 15 years of someone who does really well. There's a change in the manager's position, and now that person all of a sudden is not adequate enough, and within 6 months you let them go. And this is much like what happened here. The courts are not so open to giving the employer reason in that case. But if you can show, that you've given the employee ample opportunity to correct what they're doing wrong, and it's not a question of weeks, but if someone's there 15 years, you might have given them a year and a half, and you've given them specific objectives to reach that are considered reasonable that they haven't been able to. Well, then you have a better chance of being able to terminate someone without being found liable for all of these damages. But it's not an easy thing to do. And if I tell this to employees all the time. If you work someone for a long time, don't jump ship because another employer is willing to give you $10,000 more a year. You've built up a tremendous job security being at a company for 15 years. It's worth a lot of money, that job security. So if somebody wants to offer you a job for more money, you have to consider the total package of what you're leaving on the table when you walk away from your existing employer.
You described what sounds to me with this manager like a bit of a personality conflict, right? You do a job one way for, you said 15 years, then
right.
They change someone who you report to, they have a different way of doing business, and you get fired because it then becomes a personality conflict. So you're saying that's kind of what the courts looked at to say this had nothing to do with performance.
Or if it did, it wasn't sufficient enough. So there might have been a performance issue there, but does it merit being terminated without having all of the damages that you should be awarded? So in this case, it was not.
I want to go to another story, and it's funny because you have this in here, the Wells Fargo story. For people who haven't heard this, Wells Fargo, a big financial institution in the U.S., big company, has laid off more than a dozen employees who have been fired for faking work using a, quote, simulation of keyboard activity, what we used to call looking busy. What's this story about, Chris?
Yeah, so basically Wells Fargo is monitoring their remote workers, and they found out that they're using, I don't know if it's a software or some kind of app that simulates keyboard activity to show that they're at work when they're not at work. So they fired a whole bunch of employees that were doing this. And because of that, people started to look at the statistics. And a report came out, I think it was from one of the big HR companies, and they said that 96% of remote companies that have remote employees are investing more and more money to monitor their remote employees. But it comes with a caveat. The more you get monitored, the more likely you are to quit your job. So companies are now dealing with a problem. They're saying, well, we want to monitor them, but the more invasive the monitoring gets, the more likely the employees are going to quit, and that's not good for us either. So this is why so many companies want people to come back to work. But again, I don't think remote work is going anywhere. This hybrid model seems to be the one that works the best for everybody. The 3-day at the office, 2-day at home, or something similar to that seems to be what's working. But no question about it that some employees are, the minute they feel that they're being monitored, every keystroke, they're more likely to quit their job because they don't feel comfortable with it.
By the way, I want people to understand this. First of all, as you said, to clarify, these are only employees working from home. Are you telling me that there is a piece of software that exists that can actually make it look like you're typing on your keyboard while you're working at home, even though you're not, just to make it look to your employee like you're actually working?
See, you're not somebody.
What is the name of that software, by the way, Chris?
Yeah, you're not somebody who would do that, so you don't know. I have no idea what the software's called, but apparently it's out there and people are using it.
That's crazy.
Yeah.
And I would guess this is something that will end up in court as well. It's one thing to say we figured out that you're not doing the work. It's quite another to prove it, isn't it?
It is. But usually when you have these monitoring mechanisms, they're usually pretty good at proving that you weren't doing anything. Again, it might be challenged, but usually these kinds of things just go away, and the people that are fired don't mention it on their CV, and they try to find other work.
What a story. Okay. And I'm sure now that this has happened, we'll probably find out as well from other companies that have people working at home that they're aware of this too. So here's the next big challenge. All right.
Right.
Chris, thank you so much. Appreciate it. Is this really you, by the way, or is this AI pretending to be you?
It simulated me.
It simulated you. Sounds so good. Yeah. They're getting better at this technology. Chris Dimakos, our CJAD legal contributor. Thank you, Chris.
Thanks, Aaron.